I'd like to talk about Blassingame versus Trump, the case in which two Capitol Police officers are suing Trump, and why this case spells trouble for Trump. Remember, after Trump's second impeachment trial, Senator Mitch McConnell concluded that, quote, "There is no question, none, that Trump is practically and morally responsible for provoking the events of the day." But McConnell went on to say that the courts, not the Senate, were the proper venue for those seeking to hold Trump accountable. This is ridiculous. It was a way of punting responsibility and his own duties. It was an avoidance tactic. It was also wrong. The Senate was an appropriate place for holding Trump accountable. But courts are also an appropriate place. When these particular officers filed their papers in court, they quoted McConnell. Basically, they said, "McConnell sent us." McConnell, after listening to all the evidence in the impeachment trial, said that Trump is responsible and the courts are where we should go to hold him accountable and to get justice. So the case in which these two Capitol Police officers are suing Trump is particularly bad for Trump for a number of reasons. First, it's a civil case, not a criminal case. And civil cases are easier to prove in court because there's a lower burden of proof for the plaintiffs. I talked about this a little in the last video. In criminal cases, the prosecutor has to prove each element of a crime beyond a reasonable doubt. This is the highest possible standard because the defendant in a criminal trial stands to be punished by the government. A defendant in a criminal trial stands to lose his or her freedom. In capital cases, maybe even his or her life. Civil cases, in contrast, are mostly about who pays for damage. The law basically says that the person who causes the damage has to cover the cost of the damage. So in a case like this, we come to the same questions as in criminal cases, but with a lower standard of proof. The question is, did Trump cause the officers' injuries? Put another way, if Trump had taken a different course of action, if he hadn't insisted that the election was stolen, if he hadn't riled up the crowd during the rally itself and in the months leading up to the rally, would these officers have been injured? Another reason this case is particularly bad for Trump is the defendants are police officers who sustained serious injuries. One weakness in a lot of tort cases or injury cases, is that the plaintiffs don't have actual damages, which means they don't really have what's called standing to sue. These officers did sustain serious injuries to their heads and their backs. One continues to have back pain. They were sprayed in the face with chemicals. They were traumatized. Their lives were sort of upended. In their court filings, these officers recount in sort of harrowing detail how they were attacked with rocks and bottles and fire extinguishers and metal poles and pepper spray. Another reason that this is a particularly bad case for Trump is these are sympathetic plaintiffs, right? Aren't blue lives supposed to matter? One of these officers reported that all through the attack, the insurrectionists hurled the N-word at him. There's bad facts. Bad facts for Trump, bad facts for all of them. Now, this brings me to the next reason this case is particularly bad for Trump. Trump's defense is usually based on cherry-picking the facts. He says, "I told him to be peaceful," or "there's nothing wrong with the word fight." Cherry-picking facts like this sometimes perhaps works in the court of public opinion, particularly in certain media outlets, but you can't cherry-pick the facts in court, and these facts are really bad for Trump. When the facts that cover several months are laid out, it's devastating. The complaint filed by these police officers gives the whole history of how Trump riled his followers with lies, that he knew that these Stop the Steal rallies were leading to actual violence. On January 6th, he would have seen people in the crowds in tactical gear. And when a case like this is litigated, all these facts will be brought forward again. And the most harrowing description from the day, from any of the viewpoints from January 6th, the most harrowing viewpoint is these officers who actually engaged in hand-to-hand combat with the insurrectionists. It will not be good for Trump when all these facts come back into the news. The next reason these cases are bad for Trump: the law in Washington, D.C. is bad for Trump. Washington, D.C. has a tort called directing assault and battery. Now, Trump didn't actually hit anyone. The question is whether there's joint liability, whether Trump is also and equally responsible for the injuries. One Washington, D.C. case says that for there to be joint liability, the words spoken by the defendant don't have to be a literal call to action. He doesn't have to say, storm the Capitol and hurt people. It's enough if the words and actions of the defendants, quote, plant the seeds of action and are spoken by a person in apparent position of authority. The case law also tells us that the defendant need only have foreseen an appreciable risk of harm to others. One case on point was about a security officer in a trailer park who urged a young driver to demonstrate how fast his car could go. While speeding around the park, the young driver lost control and caused an accident. The court held that the security officer was jointly liable, even though obviously the security officer didn't say drive fast and hurt someone. It was obvious from let's see how fast your car can go in a trailer park that it was foreseeable that someone could get hurt. So if you're worried about how the plaintiffs are going to prove that Donald Trump could have or should have foreseen an appreciable risk of harm to others, don't worry. Circumstantial evidence can be used in court to prove state of mind. Circumstantial evidence just means that you look at all the circumstances and you draw a conclusion about what a person knew or should have known or could have known or whatever. Now, direct evidence, if direct evidence of state of mind was required to prove intent, the only time you'd ever be able to convict somebody for a crime would be if they confessed. So from all the facts surrounding the circumstances on January 6th and leading up to January 6th, a jury can conclude that Trump knew or should have known that there was an appreciable risk of harm. And yes, appreciable risk is vague. One side is going to argue that there was appreciable risk. The other side will argue that there wasn't. Both sides will point to case law and they'll try to distinguish. Is theirs on the side that Trump should have known or was there no foreseeable harm? In this case, I'd rather be on the side arguing that any dodo would know that if you tell this particular crowd under these particular circumstances to go stop the steal, where the goal is to stop the voting, there was obviously an appreciable risk of some harm. Another reason this case is bad for Trump, discovery in civil cases is wide open. A civil court's trying to get to the truth. In a civil court, you don't have a Fifth Amendment right to stay silent. You don't have a Fifth Amendment right unless you have criminal vulnerability. Since it isn't a criminal court, a jury can take silence into account. If you say in a civil court, I refuse to testify because I have criminal liability, it doesn't make you look good, doesn't make you look innocent, and the jury can weigh that. Because discovery is wide open in a civil case, discovery in this case is likely to bring to light evidence that the House managers in the impeachment trial were not able to get their hands on. For example, remember the reporting from close advisors to Trump that Trump watched the TV coverage in the insurrection with interest, buoyed to see that his supporters were fighting so hard on his behalf? Imagine bringing those witnesses to the stand and having them testify under oath. If a jury believes these accounts, that Trump was sort of thrilled to see the violence going on in the Capitol, it's pretty much all over for Trump with these cases. As one more reason these cases are bad for Trump, I'll throw in that Washington, D.C. would be a terrible place for Trump to face a jury. I'm sure he'd much rather be in, say, Florida, where he might have at least a hope of getting a sympathetic jury, but he has no grounds to move the case. The harm occurred in Washington, D.C. If you go someplace and hold a rally, you automatically subject yourself to the laws and the courts in that jurisdiction. Trump tends not to do well in court, where facts matter. He does well in forums where facts don't matter. For this reason, Trump is likely to try to settle his case to avoid a trial and discovery. It should be obvious to Trump and to his lawyers that if this case goes to trial, his possible outcomes range from bad to terrible. I'll be watching as this case develops, so check back for more updates. As a bonus, these videos will help prepare you for the virtual internet bar exam. Thank you for joining me. Oh, and there will be a test, so I hope you're taking notes. Thank you.